Good afternoon, all. Welcome to the Appellate Division First Department, oral arguments for today, May 28th. So again, you all, I'm sure, are familiar with the standard spiel. We are fully familiar with your briefs, with your arguments, so please only request the time that you actually need in order to get out the salient points of your argument. If there are additional questions which the bench has following the red light, we will certainly ask those questions. People v. Jose Taveras. That matter is submitted. Matter of Dior. Submitted. Chandran versus Rangan. 3 and 2, 5 and 4. Hoffman v. New York City Police Department. That matter is submitted. I'm sorry. And so there's no, I'm sorry, you said you were for the respondent? Yes. I thought, are you Hoffman? Okay. And the city is not here, police department's not here. Did you wish to submit, or did you wish to have time to argue? Okay, 3 minutes. EXRP 14 Holdings versus LS-14 Avenue. Okay, so that's 5 and 3, and you have a cross appeal? And 5 and 2. People v. Joseph Sparks. Good afternoon, request 414. Payne v. Rosenberg. Good afternoon, Justine Claremont for appellant Mala Payne. On both matters on the calendar today, I request 10 minutes for both appeals, saving 5 for the final. Yes, we are going to do both appeals together. And for Rosenberg?
Good afternoon, Your Honor. Spencer Richards on behalf of Rosenberg. I request 6 minutes for the first appeal and 2 minutes for reply. And then,
You have a cross appeal?
yes, Your Honor. And then 4 minutes for the second.
Okay, so we're going to do the two together. So for both appeals, we will do 6 and 2 and 6 and 2. KNR Construction versus Epiphany Construction.
Your Honor, appellant requests 6 and 1 for rebuttal.
Good afternoon, respondent requests 3.
5 and 1, and you requested 3? Thank you. Ivan versus Felicia. That matter is submitted. People v. Lake Smith. That matter is submitted. First case for argument is Chandran versus Rangan. Yes, whenever you're ready.
Good afternoon. May it please the court, I'm Jill Zuccardi, attorney for appellant Shruti Rangan. There is no basis in this record for requiring this young child to engage in a 1.5 to plus hour commute in traffic to and from kindergarten and grade school, where she is well established in the community of her primary residence. Even the forensic examiner opined it would be difficult. Note that the respondent's brief does not contain any sentence that begins, "It is in Annika's best interest that the father have educational decision-making because." The crux of his argument is it's not the father's fault the mother moved to Queens 6 years ago, when in fact it is, due to domestic violence. And 2, the father is a professor at Columbia.
Well, yeah, and yes, he's a professor at Columbia, and so my understanding was that he wanted to enroll the child in a school affiliated with Columbia.
He did.
And what would the problem be with that?
The commute is the main problem, but as set forth in our brief and in the attorney for the child's brief, there are various other problems depriving the mother of custodial
Well, I
time.
think it was his argument was as to the caliber of the schools which would be associated with Columbia, as opposed to the caliber of the schools perhaps in Queens where the mother was situated.
And there was nothing in the record that discussed the caliber other than anecdotal reports by the forensic that some people he knew had put their children in childcare at Columbia. The record does not, in fact, support that the child would do better at Columbia. There seems to be an assumption.
So, Counsel, you're seeking that the mother have final say in terms of education after consulting with the father?
Absolutely.
Meaningful consultation with the father?
Absolutely. And they have a parent coordinator now, as set forth in the decision. However, she is wanting the child for these young years to be closer to home for all of the reasons that are set forth in the brief.
And I don't recall anything in the record showing that the father had investigated what the gifted and talented options or any other options were in the neighborhood near where the mother resides. Did I
No,
miss
he did
anything,
not.
counsel?
He did propose, when she first was applying for kindergarten, 2 schools in Queens, and she added them to the list. But it did not appear from his testimony that he was open to the idea that a public school education, at least for the early years, was acceptable to him. We also believe it's because he wants the child to be near his residence or her school.
Thank you.
Thank you.
Your Honors, may it please the Court, Gretchen Beal Schuman for the respondent, Kartik Chandran. The Court should affirm the trial court's decision in all respects. This was an extensive, well-thought-out, creative, 94-page decision by Justice Tandra Dawson.
I'm interested in your saying it was creative because it seemed to me that the judge, whom I respect very much, made some findings that were not actually supported by the record. For example, there was some, I believe the opinion said, many children go to school, many children in New York go to school far from their homes and they're fine. Was there any evidence in the record to support that?
Your Honor, I don't know that there was specific evidence, but certainly Justice Dawson has been sitting in the part now for many, many years.
That
She's
doesn't mean she
decided-
has specific knowledge about where children go to school and how they fare.
Well, Your Honor,
Or
if I
that
could-
it's appropriate for her to rely on that in making a decision without giving notice to the parties that she's reaching a finding of fact on that, right?
Well, I do think Dr. Ravitz spoke to that point. The other issue was, Your Honor, we have to remember in
But
this
Dr.
case-
Ravitz came out and ultimately said he was he was not in favor of the child having to be subjected to a commute that long at that age, right?
Yeah, I just want to emphasize the fact that the child was 5 years old at the time. So we're talking about a 5-year-old traveling from Queens to Upper Manhattan, the Upper West Side of Manhattan. That seems to be a bit onerous on a child.
Well, Your Honor, if I could address your point. With respect to the commute has been happening throughout a very large portion of this case. Currently, the commute is happening almost half the week. So the child is going one direction or the other no matter what, whether it's to attend
many
school
days
or
a
whether
week?
it's to be at the parent's home.
When you say,
Currently,
how-
right now, it is every other weekend, but until Monday morning. It is every Wednesday to Thursday overnight with
So
the
that's
father.
twice a
And
week.
additionally,
so that's twice a week, not half a week.
Your Honor, it's 50% of the weekends, both on Fridays, Monday mornings. It's one midweek overnight every single week. Additionally, the father has substantial holiday and vacation time.
Right, so but we're talking about commuting for the purposes of a visit and an overnight stay and relaxing or doing other things with the parent, as opposed to commuting to go to school where you're actually sitting in a classroom for a period of time.
And also having to wake up earlier to make it to school on time versus a visit, a leisure visit.
Well, Your Honors, all I can say is that the commute has been happening. There were no complaints during the case or no showing that the commute was
The commute
detrimental
has
to
been
the
happening
child.
how? The father's dropping the baby back off Monday mornings to her school in Queens?
Correct, and picking her up Friday afternoons in Queens, and picking her up Wednesday afternoons in Queens, and
picking
bringing
her
her
up
back
and-
to school Thursday morning in
Okay,
Queens.
counsel, but if we were to affirm this decision, then the mother's traveling uptown to Columbia every morning for school for the baby.
No, actually, the father agreed to do all of the physical transportation.
So the
That was-
father is going, excuse me, the father is going to pick up the child every Monday, Tuesday, Wednesday, Thursday, Friday morning, take her up to Columbia and bring her back home.
That is correct, Your
And the
Honor.
father, when you say pick up, you're talking about the father's driving?
The father is either driving, arranging a car service that the father is taking, or the father is taking alternate and transportation, not expecting the mother to accompany the child. The father would be physically accompanying the child.
Is there
Your Honor.
anything in the record would suggest that Columbia, and I have no issues with Columbia, but that there's no comparable school in Queens?
Well, actually, I'd like to address that because the father, and Justice Gesmer had raised this issue as well, did make alternate suggestions other than Queens. He had looked at Hunter, which is on the east side of Manhattan.
Queens.
He had also suggested schools in Queens, including a G&T program in Queens. The mother would not agree to drop for that G&T program in Queens.
Well, could you address the passport issue?
Yeah, I could absolutely address the passport issue. It's very clear. The mother went to India on a one-way ticket in November of 2017 when she was pregnant with the child. She did not agree to return until May of 2018 and wanted to stay in India for 6 months after the child's birth.
Why does
India
that
is
make
not.
it a good, excuse me, why does that make it a good idea that the father only have to give her the passport 2 days ahead? It seems to me that that's asking for trouble, because if for some reason he doesn't turn it over in 2 days, the mother will not be able to travel at all, because there's no way she can go to court and get relief in a single day. So it seems to me that this is a disaster waiting to happen.
Well, you're right.
Why wouldn't it make more sense for there to be more time before the travel is planned, and how it, and I don't understand how that would be affected by whatever she did years ago with regard to going to her place of birth to give birth.
Well, Your Honor, to answer your question with regard to the place of birth, India is not a treaty partner to the Hague Convention, so that is obviously a concern. Number two, with regard to the 2 days, most of the time it would be 2 business days. Typically speaking, if
Doesn't
there
say
was
that.
a threat.
It didn't say that in the order, did it?
Counsel, I'm confused, I'm sorry, Ann. I'm confused. She gives him an itinerary that shows a flight leaving and a flight returning. Why, when she gives him the itinerary, he can't give her the passport? What's gonna happen?
Your Honor,
What's
that
gonna
is-
happen?
The mother has an apartment in India. She has resources in India. That is a significant time to pre-plan.
But still, what's going to happen? She is giving him the itinerary 2 weeks before.
That he can check all the way up until the flight.
Your Honor, I understand, but there were many, many concerns about this particular issue, including.
Counsel, the trial court didn't find any reason to believe that the mother would abscond with the child, correct?
I understand that.
Is that correct, though?
Your Honor, quite frankly, we argued that it is definitely a concern. I think whenever you're talking about a nation that is not a treaty partner to the United States, one trip is all it takes.
But I'm still not understanding why, if the travel is allowed, the 2 weeks in terms of notice and the itinerary, if that is allowed, what is the point of stating that the passport can only be given 2 days before? You said the order was 2 business days before. How does that prevent, if in fact the mother's going to abscond with the child or keep the child in India, how does that prevent that from occurring?
I think there's less time to contemplate a plan that would contemplate an absconsion.
I think if you're going to contemplate absconding with your child, it's going to be longer than a 2-week or 2-day period of time. But you have time on rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court? Shireen Nothenberg on behalf of the subject child.
Counsel, why? Why would the judge do that?
You know what's really interesting? Well, why would the judge do the passport provision, or why would the judge do
Why would the judge, we weren't there, it's a 94-page decision. You were, and you're the attorney for the child. Why the school and why the passport?
I think the judge was very impressed by the notion of Columbia. And certainly Columbia probably has wonderful resources for children. But let's face it, this child lives 2.5 to 3 hours round trip away from that resource. And the problem with this decision, what the judge missed, was how much the father's disdain for the mother was leaking into his decision-making with regard to the child when the child's in the care of the mother. Because let's face it, this decision did not take into account where the child resides. The child resides with her mother during the work week. And he decided to inflict an onerous commute on the child, despite the fact that the burden it's going to put on the child and the child's time
Well,
with the
counsel
mother.
for the father states that he proposed schools in Queens as well, which the mother rejected, seeming to suggest that the mother was against any gifted program.
I don't think that the testimony does not support that the mother was wholeheartedly against any gifted program.
Counsel, but the record does show that the mother included the father's name on a school form and then put her own cell phone. So there's a little bit of back and forth with these two parents.
Absolutely, but let's really take that apart. Never once does the father say he didn't get access to that child. Regardless, he was picking up the child, and the child's access was defined by the court, and there's no allegation that the mother was in any way remiss in allowing him to have as much time as he wanted, as was allotted by the court, not by
Counsel,
her.
but I think that the point is that there's acrimony going both ways.
There's 100% acrimony going both ways, but who, by virtue of this decision, who is the one who's most burdened by that? By the decision the court.
The child.
Child.
The child.
The child is the most burdened by all of this.
By all the acrimony, but also by the decision to give him decision-making power because he exercised it in a way that burdens the child. Now, let's also think about this. Who finds this commute really onerous? You know who finds it onerous? The father. Do you know how many times he complained about how onerous this commute was when he was doing it? Originally, he complained in his test, when he spoke to Dr. Ravitz, he said it was a 3-hour commute. When he was in correspondence with the mother, he said it was a 2.5-hour commute for him. When he moved to keep the mother from actually relocating to Queens, what was the primary reason why he didn't want that move? Because it was too far. Yet now it is not too far for this child to do at 5, now 6, on a daily basis.
Counsel, I have a question.
Sure.
Given what appears to be a significant financial disparity between the parties based on the assignment of respective obligations for joint obligations, and given the father's deep belief that Columbia would be a great place for the child, I was wondering if there ever was a time when the father said, hey, if you move to Manhattan, I'll help subsidize your rent so that we can do this thing that would be great for the child. Was there ever any discussion like that?
I believe that there was, he claims that he had offered to make such an offer, but I did not see that actually. To my knowledge, on the record, I did not see it actually come through anybody, through the attorneys. Here is a concrete offer. So we don't have that.
He works at Columbia, so the child would go to Columbia for free.
Well, I was just going to say that,
No, we don't
that's
know
the
that. That's
point.
not-
I was
that's
going to
not in
say
there.
that I was wondering whether that was one of the issues in terms of Columbia, is that because he does work there, there would be either a total free ride or there would be a discount. Can you address the issue as to the passport very quickly?
I just really don't understand how keeping the passport for 2 days, if the child and the mother leave because they got the passport within 2 days, guess what? And their desire is to abscond, they're going to abscond. This doesn't do anything except create tension and more problems for this family. And this family doesn't need, it needs a reduction in stress, not something that's going to create an acute problem so close to a
Do you think that this family, that the mother and the father would be able to work together in terms of figuring out the educational issues?
I think that the father has shown that he is disdainful of the mother and her decision-making. So I'm not sure that's the case. I truly believe.
Counsel, before you sit, You have no position on the visitation awarded to the father, correct?
I'm going to tell you this child enjoys spending time with the father and the mother, and we absolutely are not weighing in on that because she loves both parents, and she's very lucky to have both parents who love her, but we just need parents who respect one another.
Counsel, one last question. You just mentioned some hesitation about them being able to work together, but a part of it is that they would have to have consultation with the father regarding visitation. Do you think that that can actually occur?
With the help of a parent coordinator, yes, I do.
Okay.
Thank you.
Thank you.
I would just like to address one factual issue in rebuttal. Justice Weber, in regard to the claim that the mother refused to look at a gifted and talented program in Queens, I refer the court to Exhibit 76 in evidence, in which the appellant says, I have looked at the G&T program that you suggested in Astoria. It is 55 minutes by public transportation, a bus, and 2 different trains from my residence, and seems to be nearly as long from your residence. So that was the context in which the program, she did accept the other schools he suggested, but that was the context in which that particular school.
Counsel, how does he transport the child back and forth for visitation? By public transportation?
I don't know.
Counsel,
I'm sorry, I don't know that.
That's
I
okay.
believe he testified at trial as to many ways, the Long Island Railroad, Lyft, public transport, so I can't answer that.
That's okay.
Counsel, going back to the passport issue, is the mother prohibited from traveling to India?
No, she can post an undertaking, as both parties have deep ties there and family there.
So then what reason would the father have to object to any travel plans?
We don't know.
The father has ties there, so if she were to stay there, he can go there and go to those courts.
And Justice Gesmer, I don't think respondent would object that the parties, my client now is able to work, so the income disparity doesn't exist anymore.
I didn't know
So
that.
I wanted,
you for that.
it's outside this record, but it's still in we're still going in the lower part.
Thank you. Thank you all. Hoffman v. NYPD.
May it please the court. Good afternoon, Your Honors. Jonathan Hiles for the petitioner, Thomas Hoffman. I'd like to start briefly with the exhaustion issue to clarify the facts. Appellant NYPD disclosed 3 police reports prior to filing of the Article 78 petition. After filing the petition, NYPD produced, with its motion to dismiss, 193 pages of police reports with redactions to the names of non-testifying witnesses. That's at R93 and R55 to R60. So NYPD's position is that after it produced these 193 pages post-petition and then defended its redactions on the merits below, we have to go back to the Record Access Appeal Officer and ask them to overrule the decision of the agency attorney who actually personally reviewed and redacted the documents herself. That's at R119. And we have to do all of this because the appellant NYPD failed to locate the responsive documents in the first instance. So I think that would take government waste and inefficiency to a whole new level and be futile. On the issue of the redactions themselves, NYPD repeatedly claims that it is not seeking a blanket exemption under FOIL, but that's exactly what they're seeking. They're seeking to be able to redact the names of all non-testifying witnesses in all police reports in all homicide cases. And that's not something,
Well, I said for privacy and also I think for public safety.
right, possibility of endangerment. So they're seeking a blanket exemption that would apply to all homicide cases.
I don't know that that's blanket. Privacy, personal privacy and safety, I'm not really sure that's a blanket, but anyhow.
Right, but it would be the name of all non-testifying witnesses in all homicide cases would be automatically exempt from disclosure. So in that sense, it is a blanket exemption that they're seeking. And so there's also no limiting principle to this position. Why should it just apply to homicides? What about all violent felony cases? Why not all criminal investigations, period? So it's an unsustainable position that they sort of try to run away from, but that's what they're asking for. There's no possibility of endangerment when we're seeking documents to exculpate the person at issue. If something's exculpatory,
So,
then it's...
Counsel, I'm not understanding. Are there additional documents that you are still seeking?
We're seeking to, we're asking NYPD to unredact the names of non-testifying witnesses in those documents. So the documents have been produced. The issue now just concerns the redaction of the names of the non-testifying.
How many documents are we referring to?
193 police reports, and about half of those have the names of non-testifying witnesses. So they've redacted all of those names.
And when you say police reports, we're talking about DD5s?
Exactly.
Thank you.
Okay, thank you.
EXRP 14 Holdings versus LS-14 Avenue.
Good afternoon, Your Honors. May it please the Court. Jennifer McDougall on behalf of Appellant and Cross Respondent, LS 14 Ave LLC. This action concerns a dispute between the purchaser and the seller of a retail unit at 14th Street in Manhattan. My client, the seller, was obligated to build the unit, and EXRP, the defendant and affiliate of Xtel Development, was required to purchase the unit. And we believe that the lower court incorrectly dismissed several of our counterclaims which concern this misconduct. First is the breach of contract claim. The lower court dismissed our claim for breach.
How do you establish, in order to sustain a breach of contract claim, you have to show that you are in compliance with the contract. But the contract required that you do certain things by May 27th that you didn't do, which isn't really correctable once May 27th passes. So doesn't that defeat your breach of contract counterclaim?
So we don't believe so, Your Honor. We've cited to some case law.
I understand you don't believe, but why?
Well, this is an unusual circumstance, Your Honor, where neither party noticed a closing for the May 27th, 2022 date.
But that's not unusual. It often happens that people don't notice things that it should be, but it was still, nobody disputes that that was the closing date, right?
We don't dispute that that was the closing date set out in the Fifth Amendment.
Why isn't
to
that a
PSA.
breach of the contract on your end?
Well, if it was a breach of contract, Your Honor, we believe it was a partial breach of contract. The parties were continuing to work in good faith. There were problems with the retail unit, the storefront of the retail unit as a result of the aluminum shortage. And so
I thought that was interesting. One of the things you said was the aluminum shortages resulting from COVID-19, soaring energy prices, and the Russian invasion of Ukraine. So, is it that do we get aluminum from Ukraine, or
we do, Your
the
Honor.
Russian invasion of Ukraine caused there to be a shortage of aluminum?
Yes, Your Honor. Most of our aluminum is manufactured in Russia or Ukraine. Most of the aluminum that's exported to the United States. Because of COVID-19, there was a backup in the aluminum production, I guess in smelting. It became worse as a result of the Russian invasion of Ukraine, where essentially the production shut down.
Well, counsel, why didn't you just enter into another agreement for a different closing date, given that time was of the essence as listed in the contract?
Right, the outside closing date was May 27th. So, I mean, why was there why was there no negotiation in terms of another date?
There was, Your Honor, and that's part of our implied covenant claim, which was sustained by the lower court. What we basically say is that the parties were working together in good faith to deal with this highly unusual circumstance, and they
Given your
basically...
merger clause, if that was never resolved, then why aren't you stuck with the May 27th date, especially because it was time of the essence?
Well, Your Honor, our implied covenant claim, turning to that claim, basically says that they took advantage of this situation. They hid the fact that they weren't going to work with us, and they frustrated the point of the entire contract by, in the first place, refusing to close when we were prepared to close, and then refusing to close at any time thereafter, but also filing a notice of pendency against the property. So there was no one else, we couldn't convey it to anyone else or mitigate our damages. And to date, they still haven't closed on the property. So our allegations for the implied covenant claim, which are different than the breach of contract claim, are essentially that this was a scheme to, frustrate the point of the contract. and
Counsel, when was the property actually ready? When was it actually ready?
So there's an issue of fact as to that, Your Honor. What the plaintiffs allege is that there was an issue with the storefront, the originally planned storefront. My client had temporary certificates of occupancy prior to the May 27th, 2022 date, and again after the May 27th, 2022 date. There's a dispute as to whether the originally planned storefront was, whether the replacement one was of the same quality and standard. We believe that this is a minimal breach, if at all, a
The
partial breach.
specifications of what was to be built, was that not in the purchase sale agreement?
It is not set out in the purchase agreement. There's no specific exhibit to the purchase and sale agreement that says, it has to be made of this material or it has to be of this size. This was an agreement later made between the parties as they set out the details of what the retail unit was planned to look like.
But before you can close, you still need a certificate from the architect
Absolutely.
saying that construction is complete,
Absolutely.
according to specifications.
Yes, Your Honor, and we had that.
When did you get it? Did you get it before May 27th?
We did not, Your
You
Honor.
got it after May 27th?
Yes, because we believe that the parties were continuing to work in good faith.
But you didn't have an extension of the closing date in writing, which you had gotten before in previous occasions.
Correct, Your Honor.
Thank you.
Good afternoon, may it please the court. Jason Sorolnik on behalf of the respondent and cross appellant. Your Honor's questions were all spot on. This is not some unique case. This is not even the case, although this wouldn't matter for purposes of the claims at issue, where my client was trying to take advantage. It's the exact opposite. My client agreed to 5 separate extensions of the outside closing date.
Around May 27th, you were still involved in negotiations, correct?
Correct. On May
So why
20th.
couldn't they have assumed that you were likely to reach a resolution and therefore that they were excused from performing?
Well, because this agreement says the only way to modify it is if you have it signed writing by the other party. They did this 5 times. My client was never obligated to sign any of those 5, let alone the 6th one. My client was trying to accommodate. They did it once, twice, 3 times, 4 times, 5 times, and then we were unwilling to just continue to delay this thing out. I mean, the anniversary of this closing date is coming up tomorrow, 2 years. I don't think the unit is completed yet. We went for an inspection a year into this litigation, still wasn't done. Still no knockout slab. It's like remarkable that we are even here with them telling you things like, well, it was ready. Well, Your Honor, you asked, when did you get the architect's certificate? Because that's a specific requirement in the agreement, and you get the answer after May 27th. This is a garden variety breach of contract. Time of the essence is something that this court has addressed time and time again. There's a reason why those words appear in a contract. They mean we are not going to have these kinds of disputes. If you have time of the essence and you blow that date, and there's no fact issue whatsoever, everyone here agrees on one thing. They weren't even close on May 27th. They did not meet that date. We didn't schedule a closing. How do we schedule a closing on a unit that's not yet built? That's just farcical. I don't even understand.
Why did you file a notice of pendency?
So we brought a claim for breach of contract and for specific performance. CPLR says specific performance, we are allowed to bring both in the alternative, both under default law, and this contract in particular says you can pursue breach of contract damages and specific performance at the same time. We brought both claims, and both claims were sustained by the court. The motion to dismiss was denied. And with a specific performance, not only are you allowed to, you should file a notice of pendency to put all prospective purchasers on notice that you have this claim out there.
So you want the premises?
At the time that we filed the claim for specific performance, we absolutely did want the premises. We had a tenant that was a $20 million lease, roughly $18 to $20 million lease that we had entered into. Unfortunately, during the pendency of this case, that tenant has walked because we didn't get the unit. We went for an inspection. We tried to close on specific performance. It wasn't even done. They had us come out there for a whole inspection, a whole rigmarole, and there's construction workers on site putting things in. They didn't have the elevator shaft. I mean, it was like unbelievable. But the short answer to Your Honor's question is yes. When we sued for specific performance because we wanted the unit and we had a tenant.
So why didn't you sign an extension of the closing date?
My client was not interested in extending the outside closing date a sixth time without any concessions from the other side, because at the time that the proposed extension was raised, interest rates had changed and you have to negotiate an agreement. So my client said, we'll work with you, but you have to work with us. And their client said no. So we weren't able to reach agreement. If I can just briefly address.
But at the same time, you stopped them from going to someone else.
We didn't stop them from going to someone else, Your Honor. We filed the notice of pendency, first of all, 6 months later. They had already terminated the agreement, and they're holding on to our deposit. Your Honor, we are here 7 years after this contract was entered into. They have the deposit, not even in escrow. They still haven't given it back. And Your Honor, we were not stopping them from doing anything. We invited them to file under CPLR 6515. There are two ways to get rid of a notice of pendency. One is 6514. They filed that motion, and Justice Crane denied it because there was a proper specific performance claim. The only way you can get rid of it is if we filed for an improper purpose, and that was found to be incorrect. But there's another mechanism. All they have to do is post a bond. There's a double bonding procedure under 6515. Post a bond. We have no interest in holding the notice of pendency for 1 day more than we need to. But they didn't want to post a bond. So they had the ability, if they had any buyer out there or any interest in selling it, all they had to do is post a bond. We can't be left in a position where there's no security. This is a single purpose entity. They have the retail unit. If they sell that and we win this case, our deposit might not be coming back to us because it's not even held in escrow. And the damages that we suffered from losing the tenant are going nowhere. We needed the security from
Can we
this.
hear your argument as to the breach of the covenant of good faith?
Thank you. Yeah, thank you, Your Honor. I'll be brief on that. So all the counterclaims were dismissed with the exception of the third counterclaim for the breach of the covenant. What happened at oral argument was somewhat remarkable, Your Honor. The breach of covenant claim that Ms. McDougall just described to you was also dismissed because it was the same problem as the other claims that were asserted. But Justice Crane said, here's the thing that bothers me, though. I don't like the fact that there was a notice of pendency filed. Now, she had denied by that point in time, she had denied a motion to get rid of the notice of pendency on the grounds of bad faith, but she said, I'm going to allow this claim to proceed as a good faith and fair dealing based on the filing of a notice of pendency. Now, Your Honors, that is a remarkable thing for 3 reasons. I'll quickly tick through them because I see the red light.
Well, you have time on rebuttal, so you can tick through them on your rebuttal.
I appreciate it, okay.
Thank you, Your Honors. With respect to the implied covenant claim, what Justice Crane held was that it wasn't just the filing of the notice of pendency that supported these allegations. What she said specifically was that the plaintiff, in refusing to close on the one hand, but placing a notice of pendency on the property on the other hand, it unfairly prevented us from selling the retail unit to anyone else, and thereby it breached the covenant of good faith and fair dealing. Essentially, it frustrated our ability. They refused to close on the one hand.
If you could have posted a bond to get rid of it, wouldn't that have solved your problem?
Well, 6515, Your Honor, my understanding is that you can double bond the notice of pendency, but it doesn't actually go away. It stays in place. You have just bonded it in case
So
there's.
I thought that it would not go away, but I mean, you could then.
We still would not be able to convey the unit to anyone else with this bonded notice of pendency in place.
Why would you not be able to negotiate with others concerning I thought that was the whole purpose of the bond.
Well, Your Honor, so we would not, our client unfortunately was unable to do that. I mean, there was
Post the bond.
No, they were able to, they could have posted the bond, Your Honor, but it would not have gotten rid of the notice of pendency, and it also would not have gotten around the chilling in the market from the fact that Excel Development, who's a huge player in this market, had placed this notice of pendency, which was existing on the title. So it made our client unable to transfer the retail unit to anyone else. I think there was a question about why couldn't we have assumed that the parties were still working together in good faith after the May 27th closing date, and we did assume that. Our client carried out additional work to the retail unit, work that wasn't covered by the PSA. They carried this all out at their cost. This was work
You did that knowing that the terms of the contract were what they were and that you had no certain expectation that you would be released from having reached the contract by not being ready by May 27th.
Our client did have an expectation that the parties were working together in good faith. They had worked together in good faith for years. They were told, actually, on the day the Sixth Amendment, my client signed, they sent it to the other side. They said, we're going to sign right now. and then never did. So they were told.
That was already after May 27th.
Correct, Your Honor. But they were told time and time again, we're working together in good faith. Then when the retail unit was finally ready, it was, we're not going to close absent further financial concessions, and we're also not going to let you transfer it to anyone else. We're going to block that with the notice of pendency filing. And we did move to cancel the notice of pendency filing, and actually, plaintiffs opposed that. They fought vigorously against the cancellation of the notice of pendency, and now we're here, multiple years later, and they still haven't closed on the retail unit. So unless there's any further questions.
Thank you.
Thank you.
To start where my friend left off, not only did we offer the double bonding procedure, we invited them to double bond it, and that would have gotten rid of the notice of pendency. That is the whole purpose of 6515. We were not trying to tie up their property. We literally offered to get rid of the notice of pendency as long as a bond was posted. And the reason why is precisely what you heard right now. We cannot be left in a position where they blow the outside closing date. We work with them 5 times to extend it. They blow it over and over and over again. We have to sue to get our deposit back. They are holding on to millions of dollars for a unit they never gave us and didn't finish building on time. They're holding on to that, and they want to be able to sell the unit, which is the only form of security we have for getting back even our deposit. Our deposit's not even held in escrow. We could win this case.
Yeah, Counselor, you said that before. You were ticking off 3 things.
Thank you, Your Honor. The 3 things that I wanted to get to on the good faith and fair dealing. Number 1, you cannot maintain a good faith and fair dealing counterclaim when you are in breach. Good faith and fair dealing is a subset of breach of contract. Once you are a breaching party, which it is undisputed they breached on May 27th, 2022, they cannot say you subsequently breached the covenant in October or November of 2022 by filing a notice of pendency. Problem number 1, they cannot maintain the claim. Problem number 2, the only way you can maintain a breach of contract, good faith and fair dealing breach of contract claim, even if it was before a breach, is if it's the action that you are complaining of frustrates the purpose of the contract. The contract here was to sell the unit to my client, not for them to be able to sell their unit to other clients. So to say that our filing of a notice of pendency under the CPLR, our statutory right, in October 2022, deprived them of the very purpose of this agreement, good faith and fair dealing, turns the entire agreement on its head. That's problem number 2. Problem number 3, we didn't deprive them of anything. We've already talked about the CPLR has mechanisms for getting rid of any notice of pendency if the law permits that, and they just elected not to avail themselves of it. And finally, I'll tick off number 4 if it's okay with your honors. This is a claim that the judge came up with during argument, and her exact words were, what I don't like and what I think may meet the cause of action is you have tied up this property by putting a notice of pendency. Your honors, with all due respect, that is not the way that the law is supposed to work. You are not supposed to come up with a new argument for a claim that's not pled to try and leave them with a claim that's going to proceed. And there's a reason why the parties never briefed any of these issues. They never pled this issue because that even they understood that claim would make no sense. It doesn't meet any of the 3 requirements I just went through. Thank you, Your
People v. Joseph Sparks.
Good afternoon, Leanna Duncan on behalf of Yusuf Sparks. May it please the court. Your Honors, Mr. Sparks was sentenced to 3 to 6 years in prison for an offense which occurred under 3 minutes long. This sentence failed to adequately account—
Under 3 minutes long.
Yes.
The chain snatch in the elevator, the following to the apartment, the attempting to push, all of this was under 3 minutes long?
Yes, in the forensic report, the Dr. Goldstein had reviewed the surveillance video, and at the time that Mr. Sparks entered the elevator and when he got back in the elevator, that was, I believe, 2 minutes and 43 seconds.
And the significance is that the 3 minutes do not add up to 3 to 6 years incarceration?
The significance is that this was, in everything considered, a fairly benign crime. Mr. Sparks was under the throes of a paranoid delusion when this occurred. None of the
That's different from saying it's benign, right? Because saying it's benign means that you're saying that there's no harm to anyone. And I'm sure that the person who was followed, who was pushed into his home, who had a chain snatched off of him would not say that there was no harm.
He didn't say that he was no harm, but he did say that the injury was bruises and pain. They also did concede that Mr. Sparks never threatened violence and that it was clear that he was under a mental illness an episode. And this was corroborated by the forensic expert who did indeed.
Defense counsel did a really good job at trying to work out this plea. Didn't the court know about all these issues presented now to us regarding the mental illness? It seems like defense counsel really worked hard on this.
The court did know about all of these issues, and certainly it is a good plea deal, but it's not the lowest plea deal, and I don't think it adequately took into consideration that Mr. Sparks has spent over 1,000 days in solitary confinement. That is the equivalent to almost
That was
4
not-
years in isolation.
That was not as a result of this incident. It was a result, it was cumulative as to all the years that he spent in the system. Is that correct?
Correct, but it's the same sentiment that the
So under,
custodial.
in this particular case, he's charged, he pled guilty to rob 3, right? If he had pled to the top count, what would the sentence have been?
I believe it was 25 to life.
To life, that would be because he would be a persistent, is that correct?
Correct.
So we go from 25 to life down to 3 to 6, and now you want 2 to 4. Yes?
Yes, that's
And
what
so
we're asking
in your
for. It is the
papers,
minimum
in your-
authorized.
I'm sorry?
It is the minimum authorized.
That would be the minimum, yes. The negotiated plea obviously was a 3 to 6. In your briefs, you talk about the fact that is there a plan in place for the defendant if he were released? And what is that plan, and how would there be any assurance that the defendant would in fact abide by that plan?
Well, the prison is responsible for ensuring that inmates do have adequate housing, mental health treatment, and proper services before they're released. In this particular instance, that failed. My office is also very involved with Mr. Sparks and would developed a re-entry plan for when he was.
That was my question. I thought in your briefs, I thought I read that there was already a plan in place by your office, that your office had a plan in place wherein if he were released, there would be the mental health treatment, the insurance that he would take his medication, housing, et cetera. Is there not such a plan in place?
That's not accurate. In my brief, I just refer that my office does have a re-entry plan for when he is released. It would be impossible right now to know what services are appropriate for Mr. Sparks at this point in time compared to when he is actually being released.
How soon after, let's say that we agree with you and this sentence is reduced, and now he's released. How soon after he's released would this plan be implemented?
Immediately. As soon as my office was aware that he would be released, my office would reach out to Mr. Sparks and whatever services are being offered to him in the prison and arrange for a plan that makes sense so that he has the highest chance of success upon his release.
So what are the elements of that? What are the elements of a typical plan under your office's program?
I mean, I can't speak specifically to all of them. That's not in my wheelhouse. There are social workers that specifically deal with mental health.
Your wheelhouse should include telling us what will happen if he's released. And
Well, it's just conjecture at this point. I mean, at the time that Mr. Sparks.
you don't know what the elements are of.
I mean, I would
what the
assume
kinds of
it would
things that they
be
can
make
do.
sure that he has a medical health provider. to
Well,
make sure
counsel,
that
why, let's not assume what happened before when your office represented Mr. Sparks on
Well, this
a previous.
program was not in place at.
Oh,
You
your
did
office
say
didn't
that
have the plan
Jail
before.
failed him.
They did
correct?
fail him. The prison is responsible for making sure.
And now
that
you're
inmates-
telling us that if we reduce, you would be working with this prison that failed him the first time.
That would be one component of it. We would also make sure that he had adequate mental health service providers.
Counsel, your
upon
client
his
is
release.
6 feet 7 inches.
I'm
and
sorry?
100. Your client is 6 feet
Yes,
and 177 pounds.
yes.
And if he's not on medication, you see what happens? And you don't have a plan for us.
Well, Your Honor, respectfully, the plan that was in place last time, an appellate attorney from my office was very involved with Mr. Sparks. It was the fault of the medical providers. Mr. Sparks had tried to be admitted into 3 different psychiatric hospitals. The offense.
See, that's why I asked you about the previous plan, because the records reveal that your office was involved with Mr. Sparks during appellate issues.
My office did everything they could
Right.
possibly
But
do.
what
in
was
that
that plan before?
Well, there wasn't this specific reentry plan. The appellate
okay.
attorney who was working with him before was doing it because he believed Mr. Sparks would obviously need services when he was released, and he tried to get him admitted. The difference between Mr. Sparks being released last time or previous times was Mr. Sparks had the wherewithal to understand that he was in the throes of a paranoid delusion. He sought out counsel's
You can
help.
have a wherewithal that you're in the midst of a paranoid delusion, but you need the medication. You need a plan. So you're recognizing that you have a mental health issue is good. That's the first step. But then there has to be something else in place wherein you're going to get the medication, you're going to get the treatment, and you are going to get the supervision. I think the bottom line is, counsel, do you understand how we may be concerned with releasing or reducing a sentence, right? Wherein if we reduce the sentence on the bottom, on the 2, he would be released immediately, right? So on the 2, and he would be released immediately. So now the question is, if this individual is released immediately without any plan in place, as was stated, the failure of the prison system, et cetera, to address his issues, do you understand our concern as to releasing someone with his history, with his issues, albeit, it may be the fault to some extent of the system? But again, who is going to ensure that he does not engage in the same type of behavior or worse?
Of course I understand, but there's only so much my office can do about any of this. After Mr. Sparks was denied entry into 3 different psychiatric hospitals, and the attorney had paid for an Uber, had followed up, had contacted his parole officer who admitted that he knew
You
that.
offered in your brief that you have a new program to assist a person in this situation. That was not in effect at that time. So given the fact that you have a new program, we're trying to find out how that new program will prevent Mr. Sparks from engaging in the same kind of behavior again. And you don't seem to have an answer for that.
It's not about Mr. Sparks not engaging in that behavior. It's about ensuring that the facilities that are in place that are supposed to
But
protect
we
him.
need to know what those are, and you're not helping us here.
Well, any social worker, I'm sure, would contact those facilities and make sure that they're aware of Mr. Sparks' history and make sure that his parole officer is more.
Counsel,
That
on
didn't
this
work
incident-
before.
On this incident, Mr. Sparks calls the appellate attorney. God bless that appellate attorney who calls Uber, who calls Lyft, and even with all this assistance, this still happens.
It didn't work before. So
Your Honors, respectfully, when Mr. Sparks, if he does complete the 3 to 6 year sentence, these are still going to be issues. The pertinent point in my brief
I
is
totally
that-
agree. No, I totally agree. These are still going to be issues, but perhaps these are issues that can be addressed in the interim. I totally agree with you. These are issues, and these are very, very difficult issues. But at this point in time, a reduction means that he would be released immediately.
Right. The point I would like to stress in my brief is that Mr. Sparks' continuation in custody is exacerbating his mental illness. It is not, if you are concerned about what life looks like for Mr. Sparks when he is released from prison, keeping him in for this long is not going to rehabilitate him. We know that. We know his history. We know social science.
I totally agree. I agree with you. But by the same token, we know what happens when he's released. It's not easy. I don't know exactly what the answer is. I was kind of hopeful that perhaps there was a program that you could point us to a program. I thought I read that in your briefs. I apologize. I got it wrong. But that's what we were looking to. You have time on rebuttal. Thank you.
Good afternoon, Your Honors. Jamie Maston for the people.
So I didn't see anything in the record. Do we know how old the complainant was in this case?
The complainant, I'm sorry, Your Honor, I do not have that information at hand. What I do know is that regardless of the amount of time that it took for this crime to be completed, it is undisputed that this defendant, who is of a very large stature, chased and followed the victim down the hall. The victim was actually screaming for his father. Once they reached the apartment, the defendant shoved his body at least halfway into the apartment, and it took two people, both the victim and his father, in order to shove and prevent the defendant from continuing to enter and remain in the apartment.
Also, and this was a very lengthy negotiated plea, correct?
Absolutely, Justice Rosado. This was over 2 years that this plea was carefully crafted, thoughtfully negotiated by a defense counsel who put on the record that prior to becoming a defense counsel, she had actually been a practicing clinical psychologist for 10 years. So that actually shows that through the lens of experience,
And there was no issue when he took the plea in terms of allocution, correct?
absolutely no issue. To quite the contrary, the defendant himself affirmed that he was proceeding today under, quote, a clear mind. He was thoughtfully responding to these questions. If he needed anything repeated during the plea, he asked for it to be repeated, and the judge carefully and patiently did so. The judge really went above and beyond here to ensure that the defendant fully understood the nature of his plea, both at the plea and at sentencing as well.
So, counsel, what is the difference now? We're talking about really a year. If we're looking at the bottom, we're talking about a year, right? He would be out. If it's 2 to 4, he's out now. If it's the sentence imposed 3 to 6, he's out in maybe in a year.
I understand that concern, and yes, when looking at the bottom, that's what it appears to be. But I would respectfully ask this court to look at it from the top. This defendant got an extremely favorable plea bargain. We are only here talking about a lesser indeterminate sentence because the people already, they disposed of the top 2 counts for disposition purposes only.
You agreed to the lesser plea. You agreed to the lesser plea to the Rob 3.
That's correct, yes, which is a D nonviolent. This defendant, as a mandatory persistent felony offender, faced mandatory minimum of life sentences. Yes.
One of the issues that defense counsel raises is that another year in prison is likely, in fact, to exacerbate defendant's mental state, and that will only make the situation worse when he's released a year from now, or approximately a year from now. Do you have any way to rebut that?
I understand that these are very difficult concerns, and we do not wish to at all belittle the defendant's struggles with mental health. I would note that the Department of Probation, in their final page on their PRS, states that defendant Sparks presents himself as a threat to the community. And most directly in answering your question, they write, while imprisoned, he stands to benefit from educational pursuits, vocational training, behavior modifying therapy. So they do find at least some benefit in having the defendant have access to various programming while incarcerated.
Is he being medicated while incarcerated?
I believe that he has access to various medical and psychological treatments. I think it depends on where he is in his treatment, whether or not he's being medicated at any given point, but that I am not entirely sure. I do know that he has a very long history of mental health, which has been spotted by multiple bouts of
What kind of
medication.
injuries did the complainant sustain?
He sustained bruising to his arm, knee, and leg during the door struggle as he and his father were trying to keep the defendant out of their apartment. So between the defense counsel, who was very well informed, between the judge who took everything into consideration, we would ask that you not disturb this very thoughtful and fair sentence.
Was there any, I'm sorry, was there any issue about a victim? I was surprised that there was no victim impact statement. Could you address that?
I'm sorry, could you repeat?
I was surprised there was no victim impact statement. Could you address that?
I have no response as to why there was no victim impact statement. It depends on what happens during sentencing. I think, on the contrary, what the sentencing record really shows here is that the defendant's mental health was really at the forefront of everyone's concern here as they were crafting the plea and as they were going through the plea proceedings and imposing sentence.
Thank you.
Thank you.
Your Honors, this case is not about whether or not Mr. Sparks voluntarily entered into this plea agreement. We concede that. We are asking this court to use its authority to reduce his sentence in recognizing all of the systems that has failed Mr. Sparks from beginning when he was a child to now as an adult. Mr. Sparks has been diagnosed with over 14 psychiatric illnesses. The prison's response to that has to put him in solitary confinement for almost 4 years. That is repugnant for any individual, let alone someone who struggles with mental health illness. The social science and the forensic psychologist who evaluated Mr. Sparks said that the prison's conditions, overcrowding, solitary confinement, abuse by correctional officers, Mr. Sparks has been stabbed in the face by an inmate. All of these things are exacerbating his mental illness. It defies logic for this court to in turn say, we are going to continue incarcerating you, knowing the damage that is being done inside of that prison. This court has the authority to reduce his sentence to allow him, with the help of my office, with the social workers that have more knowledge about things that I cannot speak to today, try to ensure that a program can give him a chance. Right now, this court, in continuing his sentence, is decreasing his chances at rehabilitation. We know that. He has been incarcerated since he was 18 years old. He has spent more than half of his life incarcerated, and he has been received 3 different sentences. This system is not working.
Imprisonment was when he was 14.
I thought so too.
Correct, yes.
So not since he was 18, but since he was 14.
Well, he was sentenced to a several-month stay in Spofford Detention Center when he was 14. Then when he was 18, he was convicted of robbery. And when he was 20, he was convicted of assault and then this conviction. I mean, he has not been out of jail for more than 2 months since he was 18 years old. This system is failing him, and we are asking this court to recognize that and reduce his sentence.
Thank you. Thank you.
Thank
both.
you.
Payne v. Rosenberg. So as I stated, we're doing both appeals at the same time.
Thank you, Your Honour, yes. Good afternoon, may it please the court. I am Justine Claire Moran. I represent the appellant Camilla Payne in 2 appeals today, arising from the same Supreme Court case between appellant and our former attorneys Rosenberg, Mink, Folkoff and Wolf concerning allegations of legal malpractice and deceptive business conduct.
Could you address specifically what part of the retainer agreement your client you believe is ambiguous?
Certainly, Your Honour. The text of the retainer agreement in this case states on page record 32 in the record of this particular appeal that the respondent's 33 1/3% contingent fees will be collected from any judgment. The retainer agreement also provides a mechanism whereby...
Now, I think we're talking about what the obligations are. The retainer agreement states that the firm is retained to prosecute a claim for personal injury and damages arising from an accident that happened on March 4, 2015, through the negligence of others. Client gives the firm the exclusive right to take all legal steps to enforce the claim through trial, settlement, or arbitration. So how does that then translate to the responsibility of the firm to actually collect the monies that were awarded after the default?
Well, it doesn't preclude it, Your Honour, and that was Ms. Payne's understanding.
But it doesn't state specifically, it doesn't state that that is one of the responsibilities of the firm, nor does it state that she is retaining the firm to do so.
But, Your Honour, retainer agreements are held to a higher standard. Attorneys have ethical and fiduciary obligations to ensure that a client understands the scope of representation and understands the fees to be allocated. This retainer agreement does not state they will not collect judgment, and it doesn't state that she'd have to incur the expense of retaining additional collections counsel.
Which it does about the appeals. When it mentions the appeals, it says that they will not prosecute an appeal for the client.
It says that they have the right but not the obligation, and it also provides a mechanism on page 235, clause 5, whereby if different appellate counsel are appointed, respondent can still collect their
Well, it
contingent
says the firm shall not, the firm shall have the right, but not the obligation to represent the client on appeal.
But it also says that they can make an application to collect their contingent fee in that circumstance where someone else handles the appeal. But there's no equivalent provision when collection counsel are appointed.
Now, at some point, they did notify your client that she was to find a collection agency or someone to actually collect those monies. Is that correct?
That is correct, Your Honour. The representation commenced 2015, March, through various delays, default judgment, even though the defendant defaulted immediately and didn't answer. Default judgment was not entered until March 2018. And then for 18 months, my client, Miss Payne, thought that the respondent was collecting her judgment. And there is correspondence in the record from Mr. Wolf, her point of contact at the firm, telling her that he was doing so. He sent a check to the defendant to see if it was cashed. Miss Payne did not let her judgment just sit. She was actively asking her attorney, who she trusted, who'd handled matters for her before, what's happening with my judgment.
I'm sorry, you're stating that there, in the record, there's evidence in the record that the firm stated to her that they were in the midst of collecting the judgment?
It's in the record at pages 232 to 234. It's email correspondence between my client, Miss Payne, and Mr. Wolf, who was her point of contact at the firm. So here we are, it's more than a year since the judgment has been entered, and he's telling her, this is what's going on with the judgment. I've sent them a check. It's not until September 2019, 18 months after the judgment was entered, he asks her to come into the office and tells her that he's going to give her a number for a collections attorney. So all that time, she was under the impression he was acting for her, and she had an expectation, not based on her assumption, but based on correspondence with Mr. Wolf. Unfortunately, Mr. Wolf was not taking action, and while this case was basically in abeyance, a party who they did not include as a defendant in the personal injury action brought a successful action to transfer.
So that's Mr. Bernard. And in the record, I saw that there's some indication your client made the firm aware of Mr. Bernard's existence or the fact that he had a mortgage on the property?
In March 2015, before the commencement of the personal injury action, my client, who is a licensed real estate broker in Brooklyn, looked up the public records. It's right there on ACRIS. And it showed the deed was in the name of an LLC, Chibs, but there was an outstanding mortgage of record in the name of Mr. Bernard. She specifically advised the respondent of that, and they claim they chose not to make him a defendant in the personal injury action.
Thank you. You have time on rebuttal.
Thank you.
Thank you, Your Honor. To make, please the court, Spencer Richards on behalf of Rosenberg, Mink, Volkov, and Wolf. Your Honors are correct to question how the retainer agreement itself is ambiguous.
Counsel, what do you say to your adversary's representation regarding record 234 to 232 to 234 regarding the email?
Yes, the emails appear to occur between August 2019 and September of 2019. And the email explains, the firm says, when you come back from your trip from Japan, I'll refer you to counsel to
Before
collect the
that,
judgment.
They said, I sent them a check, I'm waiting to determine if they deposited it. So you're skipping what they said, what your
It's on
client said in
July 2nd. She sends an email saying, I'm checking in to see if there are any updates or response from Chibs.
Right. I don't understand what that email, how that email suggests that they're seeking to collect the judgment. What that looked like to me was they were checking to see if Chibs even existed as an entity where a judgment could be collected. And I think there's a distinction here where we are conflating whether or not this entity that fell into default because of the personal injury action and also fell into default in a separate fraudulent inducement action commenced by Bernard, whether or not that entity existed. Because
Why wouldn't a layperson have assumed from that that they were in fact going after, that the law firm was pursuing enforcement of the judgment? Otherwise, why would they be doing that? They didn't
Sending
say,
the check,
I mean,
Your Honor.
when she emailed them on the morning of July 2nd, they didn't write back and say, oh, we're done. They said, we've sent a check, we're waiting for it to find out. Why wouldn't it be appropriate for her to assume from that they were continuing to seek to enforce the judgment?
And what would be the point to seeing if this was still a solvent company, if not to obtain some judgment?
Right, Your Honor, and that's specifically why the firm referred plaintiff in September of 2019 to Collections Counsel to collect the judgment. And that referral occurred prior to the order in Bernard's fraudulent inducement action expunging all claims against the premises.
Right, counsel, but the emails that we're referencing are from July before September, which seem to indicate that the plaintiff is looking to your firm to find out what's happening with enforcing that judgment or collecting on that judgment. And the response is essentially that your firm is checking to see whether, in fact, that company is solvent.
Correct, Your Honor. And the firm itself is a personal injury firm. They are not a collections firm. And so their ability to determine how to collect a judgment from an entity that may or may not
And this
exist is not
layperson plaintiff was advised of that how?
in September of 2019, before the judgment was expunged in Bernard's separate action, the firm referred.
Retainer, how was she advised that this was exclusively a personal injury attorney firm and not a firm that engaged in enforcement? How was that advised? How was she advised of that?
Well, I think at the time when the plaintiff executed the retainer agreement, neither party knew of Bernard. Neither party knew that the judge.
That has nothing to do with it. When was she advised of whether or not the firm would enforce a judgment?
I can state in the record, Your Honor, that the plaintiff was advised on September 2019.
No, I'm talking about at the time she signed the retainer agreement, how was she advised that the firm would not enforce any judgment they obtained?
Well, the firm explained in the retainer agreement that it
Where?
would enforce on the first page of the retainer agreement.
Does it say that you would not be collecting any
No,
judgment?
the retainer agreement specifically expresses that it will force the claim through trial, settlement, or arbitration.
And
It does
you-
not state that the firm will commence post-judgment collections proceedings.
Okay, and I take it that the plaintiff is not an attorney and would not be familiar with certain legal terms and wouldn't probably know the difference between obtaining a judgment and collecting on the judgment, unless it is specifically stated in the document, maybe?
Perhaps, and the retainer agreement would be 8 to 9, maybe 10 pages longer, and the firm would have to consider all possibilities that
No, you would
this
simply
entity
have
would
to
not
state
exist.
that, collection is up to you. But you, client, you client, and not us. My question is, I'm a little unclear. So, under the retainer agreement, are you not entitled to a percentage of the judgment that, under the default judgment?
Correct, Your Honor.
Okay, so I'm the plaintiff, and I go to you, your firm, in order for you to prosecute my my personal injury case. So I signed a retainer, and I know that you're going to get a percentage, 33 1/3, I think is what you get, right? I think pursuant to. But me as a layperson, I would not think, therefore, that since you have a vested interest in that 33 1/3, that it would not be to your benefit, therefore, for you to attempt to recover those monies because you want your 33 1/3.
Right, and attorneys do enter into referral agreements, which is what occurred
Oh,
here.
but all I'm saying is, as a layperson, when I go to a firm and I know that you're going to get 33 and a third, in my mind, I'm thinking, well, obviously, since they're going to get 33 and a third of whatever monies are awarded, and there was in fact a judgment, I'm going to think, well, you're going to fight to get that 33 and a third because you want that money.
Correct. And at the time, Your Honor, in September of 2019, the firm made it clear that they were not going to collect the judgment.
But
And
when
so
I go to you in 2015, which is 4 years 4 years before, do I know that? I'm thinking any monies that are recovered, you are going to fight to get your percentage so that I get my money. And the retainer agreement does not spell that out.
I think that assumes that Chibbs itself, the defendant in the personal injury action, was an actual.
No, that assumes that any money which you work to get, you are going to make sure that it is recovered so that you get your 33 and a third.
But right, there was no money recovered here. And that's the
There was
issue.
a judgment.
Correct. And that judgment was entered against Chibbs, which does not exist. And so there was no money for the firm to recover. And so that's why.
Right, but we're talking about from the inception, from the retainer agreement, where it's indicated that if there's a judgment, that your firm will get its 33 and a third from that judgment, right? So as a client looking at this, where you've took pains to spell out what will happen with the appellate process, a client looking at it says, well, this firm's going to get their money from any judgment, so therefore they'll probably be also trying to enforce that judgment so that they can get their money.
I don't disagree. And that's why the firm recommended a referral to a specialized individual that would enforce the judgment
Years
against Chibbs.
later,
Yeah.
years later.
So in your retainer agreements, maybe going forward, you should say, we are not responsible for the collection of any monies that are in fact recovered.
But if those monies are collected, we'll take our portion.
Yeah, we'll take our 33 and a third. But could you address the Jean or Jean Bernard issue? Was there a reason why that individual was not also made a part of the lawsuit, given the fact that he, and I'm assuming it's a he, had a mortgage on the property?
Yes, unbeknownst to either party, although appellant did know that Bernard had a prior mortgage on the property.
But that's not unbeknownst.
Unbeknownst to either party, they didn't know that there was an agreement between Chibbs and Jean Bernard, whereby Bernard would take out the mortgage and then transfer the premises, the title and possession, to Chibbs. And then Chibbs would then pay for the mortgage.
So, but if you had investigated, or if you had at least named Bernard as a part of the lawsuit and or investigated, you would have known about this, right?
Perhaps, Your Honor. Perhaps they would have known about that. But the issue here is that even with that investigation, there's no allegation in the complaint that Chibbs owed a duty to prevent the trip and fall that happened on the premises.
That
There's no-
Chibbs owed a duty.
that Bernard owed a duty? Thank you, Your Honor. There's no allegation in the complaint that Bernard was aware of the snow and ice, that Bernard caused, created, or exacerbated the snow and ice condition. And so all we have here is the allegation that Bernard had a prior mortgage on the property and transferred title and possession to Chibbs. And so that alone does not give rise to a duty to prevent personal injury on property that a person does not possess, does not have title to, and if it did, then.
But we
anyone
don't
could
know
be
what the
responsible.
agreement between Bernard and Chibbs was, right? We don't know whether Bernard retained any care and repairs, maintenance, et cetera, of the property.
We do know, Your Honor. In Bernard's separate action, Bernard commenced an action for fraudulent inducement because Chibbs promised to pay back the mortgage by collecting rents on the property. In other words, when the judge in Bernard's separate fraudulent inducement action expunged all claims against the premises, including would-be appellant's personal injury claim, the judge there recognized that Bernard had no possession of the property. And so all claims were expunged, not just some. So tax liens would have been expunged, issues with tenants would have been expunged, and yes, a trip and fall on the premises would have been expunged. No discovery is required here to determine that the judge in Bernard's action had the firm even commenced the action against Bernard, would have expunged the claim, would not have expunged the claim. And
Thank
so
you.
that,
Thank you very much.
Going back to the beginning, when Ms. Payne retained the respondent to bring out personal injury action and pointed out that there was a mortgage of record, a person cannot have a mortgage of record unless they're an owner of a property. Respondent did not do any investigation to determine if he was in possession of the property, what his ownership interest was. Nothing was done. Instead, they claimed they used their professional judgment to decide he wasn't a necessary party. And that hurt my client, because if Bernard had been made a party, either he would have denied ownership of the property, in which case he couldn't have got the deed expunged, he wouldn't have beneficial ownership, or he would have admitted it, but judgment against him personally could have been enforced. It wouldn't have been affected by the expungement order. So I really think it was a serious omission on the part of respondent. I also want to draw the court's attention to the fact that throughout respondents' papers, they repeatedly claim that their representation of Ms. Payne ended in March 2018, which is demonstrably not true. I've already referred the court to the email correspondence. You can see Mr. Wolf calling her in for a meeting in September 2019. Furthermore, Ms. Payne is the only person with actual knowledge who offered testimony on this motion to dismiss. Although respondent had the opportunity, there is no affirmation from the attorney who actually dealt with her, who explained the retainer agreement to her, who explained the obligations. Instead, respondent relies on affirmation of its counsel here.
Thank you both.
Thank you.
A&R Construction versus Epiphany Construction. Oh, I'm sorry, did you have a rebuttal?
Yeah, I think he had.
Oh, I'm sorry, apologies. Yes, you do, you have 2 minutes. I'll be very fast. No, it's okay.
Counsel, before you get started, you kept pointing us to the September 2019 date. Is that the date that you contend that the firm ceased representing Ms. Payne?
I'm sorry, I didn't understand your question. Is that the date that the firm ceased representation? No, Your Honor, the date that the firm ceased representation is the day that they filed the notice of entry, which occurred in March of 2018. Anything that occurred after that, Your Honor, where appellant argues is a part of the continuous representation doctrine to extend the statute of limitations, those were all ministerial acts. There was nothing.
How was she to know that? Why would she not have thought that you were still her lawyers? It seems to me that most lay people would think if a law firm was doing work for it that they were still representing her, then that the concept of a ministerial act wouldn't be obvious. Was she ever advised that you were no longer representing her and that you were just going to do some paper cleanup for her?
I don't believe so, Your Honor. I think here what happened was that the firm entered the notice of entry and then didn't do anything else because there was nothing else that could be done to collect the judgment.
About notifying the client, we are no longer representing you. Go get a collection lawyer. When did that happen?
When did it happen?
Yeah.
In September of 2019.
September of 2019.
But again, that's a ministerial act. That doesn't necessarily mean that after March of 2019 that
So it's
Ms. Payne was
ministerial to have no one representing your interest in an action? That's
well,
ministerial?
if there's no further agreement and if there's nothing else that needs to be done on the action, then it's ministerial because there was nothing else that could have been done.
So you're stating that your representation ended prior to the realization that Bernard had taken out had the mortgage, and therefore you couldn't collect against Chips?
Yes, Your Honor. The issue here is that the notice of entry was filed in March of 2018. And so anything that occurred after that was all ministerial. There's nothing that appellant and the firm agreed to whereby the firm would continue to
But you
work
didn't
on
know at
behalf-
that point that you wouldn't be able to collect your 33 1/3.
And there was no collection of the 33 1/3.
But at
so
the
nothing else
time that
happened.
you're stating that your representation ended, you did not know that you would not be able to collect the 33 1/3.
Yes, and even if
And
there
that's
was,
okay? That would be okay for the firm?
if there was collection, if Chibs was an actual entity that could be collected from, that collection itself wouldn't have been a product of continuing the representation. That would have been a ministerial act. But Chibs was not even.
Counsel, but if the representation ended, why are they calling her into your office July of 2019?
To refer her to a separate counsel to collect the
You
judgment.
have to bring her in for that? You can't just say, here's some referral lawyers, we're not gonna.
There was some prior relationship between the parties, and so this is not the only case that the firm represented her on.
You said the representation ended, and we have an email from July 2019 where someone in your firm is saying, we mailed him a check, and please come in to see me. And you're
Right.
saying that was ministerial?
And that's not, and exactly, that is not the firm providing legal advice on her specific claim.
So attempting to find out whether in fact this debtor is solvent is ministerial, right?
Yes, sure.
Okay.
And just to be very quickly, the deed here is on page 58, and it reflects, contrary to appellant's argument here, that Bernard granted the property to Chibs. Chibs is the grantee. Bernard had no title, and then the court, in the expungement order on page 88, awards possession and title back to Bernard in December of 2019. And that's after the firm advised plaintiff to find separate collections counsel to enforce the judgment against Chibs. And that's even if Chibs were an entity. We now know that Chibs was not. And so
Thank you. Thank
in
you.
any event, there would not have been any enforcement of a judgment. Thank you, Your Honor.
Now, KNR Construction v. Epiphany Construction.
Good afternoon, Your Honors. May it please the court, Joseph Deneen for the appellant. The motion for summary judgment that was made by the appellant in the Supreme Court had a requirement of showing three things. One, that there was an amount due to it from Epiphany Construction. Nobody else, not Pilla, not Arch, one entity, Epiphany Construction.
And how did you show that?
We showed that by indicating we attached the default judgment, which had
But
been
a
entered.
default judgment isn't a determination on the merits, is it?
It fixed the amount that was due from to KNR from Epiphany. But what is critical on this appeal, and what I asked the court to take very careful note of, is that the default judgment was entered with the full approval, acquiescence, everything else of Arch. They joined in the motion. They said, we want a default judgment to be entered against Epiphany in favor of KNR in the principal sum of $74,000 plus. They could have said nothing. They could have said, well, we think it's less.
But how does that excuse you of your obligation to prove that at the point when you came in on this matter?
Because it's, to me, Your Honor, it's evidence that Arch was in agreement that the amount due to KNR was $74,000. Otherwise, why would they support the default judgment in the first place? So we have that fact, and the argument that's made in our brief is that this basically stops Arch from now coming in under either the law of the case doctrine or collateral estoppel or any intra-action res judicata, of now coming in and saying, well, now my position has changed. Now they're coming after me. And so therefore, I want to contest the amount that's due KNR.
Arch is coming after you?
I'm sorry?
Arch is coming after you?
Well, he's defending.
But again, I'm back to the $74,000. Don't you have to show that you performed the work and that the work was $74,000, amounted to $74,000?
And there was evidence throughout the record, Your Honor. There was the testimony of the managing member of KNR. There was also emails which were described by the lower court as vague. They're not vague at all. They provide a full accounting of all of the monies that were billed, all of the monies that were paid, and what the outstanding balance was.
Do you have the change orders of the work that was done in order to collect the $74,000?
Well, part of the change orders, well, there were change orders in excess of $74,000. What happened was there was approximately an original contract, which is attested to in the moving papers, of about $560,000. There was nearly $400,000 in change orders, and together it added up to a total of $990,000. We were paid $915,000. The difference was $74,000. The emails indicate that Epiphany is sending the check for the full amount, and then nothing happens. So there was no dispute that the amount was owed. I should add also that in those emails where Epiphany acknowledges that they owe the $74,000, the principal on the bond, Pilla, is copied on all of them. So Pilla knows fully what's going on. I think at the crux of this case is the fact that when K&R filed its lien, rather than having Epiphany post a bond or pay K&R the way they said they were in their emails, Pilla went out and filed a bond and got Arch to post a lien discharge bond. What happened after that was, rather than making sure that Epiphany took care of its obligation to K&R, Pilla paid Epiphany another $200,000 without making sure that the K&R lien was taken care of. So now Pilla wants this court to think that somehow K&R has to prove a case against Pilla. That's not the case. We proved our case against K&R, the documentation that was submitted, and I agree with the panel, we could have submitted a lot more documentation. Could have put in thousands of pages of stuff, but it wouldn't change the end result, which is that Epiphany acknowledged they owed the money. Everybody, when the motion for default was made, Arch and Pilla said, yes, enter a judgment against Epiphany for the $74,000. So, you know, the bottom line is also when the motion was made for the default judgment, not only did Arch indicate that it was in agreement with entering a judgment against Epiphany, but it also sought common law and contractual indemnity for the full amount of the $74,000, which it clearly understood it was going to have to pay somewhere down the pike. That's why it was asking for the indemnification.
Thank
It
you.
didn't make a formal motion. Thank you, Your Honor.
Good afternoon, Your Honors. Amanda Nelson of Cozen O'Connor for the respondent.
So if everybody agrees as to the amount and the $74,000 and Arch agrees, what's the problem?
We don't agree. I think it starts from there. There was no agreement as to the amount. There was only an agreement that Epiphany failed to appear once its counsel was relieved of their obligation.
Well, there's a default against Epiphany for the $74,872.21, right?
That is the judgment. And that, as far as we know, which we don't know because, as was noted by the court, there's been absolutely no documentation. In fact, not even an affidavit until reply saying what work was done, and even that only speaks to $33,000.
But do you agree that you supported the entry of that default judgment in that amount?
Not in that amount. We agree that we supported the entry of a judgment because the party failed to appear, and that was it.
You didn't support the amount of the judgment?
We had no standing, we had no position on the amount. And frankly, there is that additional issue. What is or what may be due from Epiphany is not necessarily what's due from J. Pilla. And therefore, what's due by the surety, Arch, because this discharge bond attaches to the contract, as this court recognized, for example, in Sette Giuliano or Varlata. It doesn't stop at the subcontractor. You don't get to get a default against the subcontractor and then everyone is bound on the way up. Rather, they were obligated to show not merely the amount, but that it is chargeable against the lien. And in this case, that includes demonstrating that it's chargeable against J. Pilla and that J. Pilla had approved the change orders. Apparently, this entire amount is made up of change orders, had approved them in writing as explicitly
Did
required.
J. Pilla approve every single one of the change orders that they submitted prior to the work being done?
Not that I'm aware of, no.
But they were paid. They were paid on those change orders.
They were paying Epiphany. So they paid Epiphany for the amounts that were due. Now, Epiphany was entitled under the contract, again, much like Sette Giuliano, to perform the work themselves. I think ultimately it was $2.3 million. They're claiming $900,000. They believe they owed Epiphany that money. Whether Epiphany owed K&R that money is a totally different issue.
But weren't you on notice by then that they were claiming you, Epiphany owed them $74,000?
They were on notice that the lien had been filed.
Yeah.
So there is no dispute that there was a lien fund in that sense, that they believe they owed Epiphany money, they paid the Epiphany money, they paid Epiphany the money, even though the lien had been filed. But as far as them demonstrating that the amount of the lien is either, that the lien is valid, that it's proper, they didn't do that in the first instance. Then in the second instance, they didn't meet their prima facie burden. And then there were issues of fact by their own documents, including the very letter they submitted saying that they completed their work in September 2017.
Thank you.
Great. Thank you, Your Honors.
Very briefly, Your Honors, I would respectfully refer the panel to the reply brief, which deals with all these so-called issues of fact. All of them were refuted, not only in the court below, but indicated in the reply brief. There were no factual issues raised. As a matter of fact, one of the factual issues alleged is that there was no lien fund. And in the reality of the situation, Arch stipulated, they admitted in the statement of material fact that there was a lien fund, and yet they argue in opposition that we failed to prove a lien fund. This is typical of the opposition that was put in on all the alleged factual questions. There weren't factual questions, and I don't have a contract with Pilla. I don't have to prove that Pilla approved anything. The money is owed from Epiphany to me, and there's a fund which Pilla could have held back some money to make sure my lien was taken care of. It failed to do that, and now it wants to basically say, I made a mistake, don't penalize me. But don't penalize the appellant. That's not fair. They did the work. The lien law is a remedial statute. It says we want to pay all laborers for the work that they do, and that should happen in this case.
Thank you. Thank you both.